We're talking about appointed representatives, and we're talking about that because the topic as a whole is in the spotlight at the moment thanks to the FCA's scrutiny of the regime. You might be wondering about what sort of brought that about, just by way of background, and the answer to that, it can be traced back to an Australian man called Lex Greensill, who you may have heard of, who started an organisation that became quite a large bank specialising in trade finance, and which spectacularly collapsed in 2021, causing massive losses to investors and contributing to the collapse and takeover of Credit Suisse. So obviously questions were asked and inquiries were raised, how did it happen? Why didn't the FCA or the PRA see it coming? And the short answer to that was that Greensill Bank wasn't regulated by the PRA or the FCA. Now, largely it didn't need to be because it was originating loans, and that's not regulated activity. But it did carry out the business of generating investment in itself in order to use that money to make its loans. And in order to do that, it was an appointed representative, meaning that it wasn't directly regulated by or supervised by the FCA or the PRA. And in the course of the Parliamentary Select Committee's investigation into all of this, the FCA told the Select Committee this regime was created back in the 80s for one-man band insurance salesmen and IFAs. It has taken on a life of its own, and we now need to look at it quite carefully because this is not what it was for. And that is what has, as it were, started the ball rolling in terms of the FCA looking at it. Just to give you a sort of a general overview of where this fits into the financial services regime, I'm sure you're all familiar with this, but appointed representatives can inhabit lots of different skins. So the sort of typical examples would be an IFA network. You've got lots of individual self-employed IFAs who are appointed representatives, or mortgage brokers who are tied to credit institutions who are selling mortgages for those institutions. But you also find them in less obvious areas. So you might have a holiday cottage letting company, for example, which sells holiday cancellation insurance, and it might find that it's easier for it to become an appointed representative of the insurer that it's selling it for than farming it out or running the risk of itself breaching the regulatory perimeter. Consumer retail. Consumer retail often involves some element of consumer credit, where there are products being sold on credit. So consumer retail organisations might find it's useful for themselves or some organisation within the group to become an appointed representative. So these things are everywhere in the financial services landscape. So that's, as it were, by way of introduction, and these are the topics that we're covering in brief. What are they? How can a principal become liable for the actions of an appointed representative? What supervision does a principal exercise over an appointed representative? And then we'll get on to the FCA's improvements in the regime and where that's going next. So I'll hand over at that point to Will.
Thanks, Shail. Well, I think it's worth at the outset going back to basics somewhat and briefly recapping exactly what an appointed representative is and how they become appointed. As I'm sure many of you will be aware, Section 19 of FSMA permits only an authorised person or an exempt person to carry on a regulated activity in the UK. Authorised persons are those who are expressly permitted by the FCA to carry on regulated activities. ARs, on the other hand, are one category of exempt person. So they're appointed by an authorised person, known as their principal, who's then responsible for the AR's compliance with regulatory requirements. And essentially this regime was designed to reduce the regulatory burden, both on the FCA, but also on the very large number of individuals who Shail was just talking about. And for context, there's currently around 37,000 appointed representatives operating in the UK, with around 3,400 principals. And as you can see on the screen, the critical section is section 39.1 of FSMA, and it sets out the steps which establish the exemption of ARs. So first, there has to be a contract known as the AR agreement between the principal and the AR, which permits or requires the AR to carry on business of a prescribed description. Second, the AR must be someone for whose activities in carrying on the whole or part of that business, the principal has accepted responsibility in writing. And then, if both of the first two steps are satisfied, the AR is exempt from the general prohibition in relation to any regulated activity comprising the carrying on of that business for which the principal has accepted responsibility. But what's generated by far the most interest, and what we're going to focus on today in the first half of this talk, is how under this regime a principal might be found to have civil liability for the actions of its ARs. Now, of course, it's always possible for someone to bring a claim against an individual AR directly. So by way of example, if you're an individual who's received bad investment advice from your IFA, you might be able to bring a claim against the IFA personally. And as you can see, there are various causes of action this might be based on, whether it's breach of contract, negligence, or perhaps even breach of relevant FCA rules, such as the COBS rules found in the FCA handbook. But as I'm sure you'll also be aware, in many cases, that individual AR may not be insured and they may not have deep pockets, and therefore, even if the claim succeeded, there's a real possibility they wouldn't have the resources to satisfy a judgment, and ultimately the game wouldn't be worth the candle. And so what one often sees is that the real target in such claims becomes not the AR itself, but rather the principal who appointed the AR. And speaking very broadly, there are three potential routes by which the liability of that principal might be established. The first route is under Section 39 of FSMA itself, and in particular, Section 39(3), which provides that a principal is responsible as if he had expressly permitted it for anything done or omitted by the AR in carrying on the business for which the principal has accepted responsibility. And as we'll see in a moment, it's those final words which are critical. The second possible route is via agency, and it's certainly plausible that an appointed representative may be found to have been acting with either the actual or ostensible authority of the principal, such that liability is established that way. And finally, it could be possible to bring a claim against a principal on the basis that they're vicariously liable for the actions or omissions of their ARs. But as we'll see, that in our experience is the most difficult route. It's really the first route, Section 39(3), which has generated the most debate, and so it's worth examining what that section actually provides. What it says is that a principal is liable, but only to the extent that the AR was carrying on business for which the principal has accepted responsibility, and therefore business in respect of which the AR is an exempt person. And as the Court of Appeal put it in the seminal case of Anderson and Sense Network, this is essentially a quid pro quo. And as you'll see on the screen there, exemption and liability under Section 39(3) are coextensive. So in order to find the area for which the principal may be liable, you need to find the area for which they've accepted responsibility and for which the AR is therefore exempt. That's always going to be the critical question. Has the principal accepted responsibility for the business which the AR was carrying on, which gave rise to the claim? And with that, I'll hand back to Shail to look at the facts in Anderson and what was actually decided in that case.
So this is the leading case really on these issues, and it was a group action with 95 investors. Sense was an IFA network, so it had a series of appointments, still is an IFA network, has a series of appointed representatives who are IFAs. It's a common setup. One of its appointed representatives was called Midas, and that was an appointed representative who had a little sideshow going on, which was what they sold as a high-interest deposit scheme, thanks to their particular links to a particular bank. And that turned out to be a Ponzi scheme. There wasn't a scheme that was being sold at all. And that scheme was hidden from Sense by the appointed representative. So as we discussed with Will, the question is, what is the business for which the principal, Sense, had accepted liability, and did it include this? On the face of it, the claimants have a problem. Clearly, operating a Ponzi scheme, or even operating a collective investment scheme, which it turned out to be, an unauthorised one, was not business for which Sense had accepted responsibility. So the claimants came up with their first creative argument. What the AR agreement did do was authorise Midas to advise on investments. Units in a collective investment scheme are investments under FSMA, and so they argued this advisory business was Sense's responsibility. Now, that argument ran into a further hurdle, which was that the AR agreement did provide for investment advice, but only in respect of what were called the company agencies. In other words, products which Sense itself had an agency to sell from the product providers, be they the funds or insurance companies or whatever they are. Now that required a second creative argument from the claimants. And the claimants said to the judge, as it were, look, judge, you can't restrict what you're accepting responsibility for in this way, because if you could, where would it end? You could say to the AR, right, you're authorised to sell investments, but you're not authorised to do so negligently. Now, if that were the case, the whole regime would fail to work, and cease to work. And how then can you distinguish between a restriction about the what question and a restriction about the how question, what the business is and how the business is conducted? And if we're right about all of that, Judge, the only thing you can do is draw the line at the highest level of abstraction. So you go back to the AR regulations, which set out the prescribed activities which it's possible for an authorised firm to delegate to the AR. You look at the way it's described in the AR regs, and if that type of activity is delegated, then you go with it hook, line and sinker, and it's not possible to derogate from it. Court of Appeal said, nice try, but no. The Court of Appeal thought, and the High Court, was basically making it up as you go, and there was no call for it in the language of the statute. So the conclusion was that the question is not a question of statutory construction looking at the AR regs, it's a question of fact. What is the business on the facts of the case that has been delegated? And the Court of Appeal took the view that distinguishing between the what and the how question in most cases should be straightforward. In any event, in the case of Anderson and Sense, the answer was clear, that it was a what question. You could advise on investments, but only in respect of these particular investments. So that being the case, you'll see from the second quote there, the answer on the facts of the case was a straightforward one. Advising clients to entrust their money to the scheme being operated by minors did not involve the use of a company agency, therefore fell outside the business for which Sense had accepted responsibility. Claimants lose. In a sense, not a surprising or an unfair decision on the facts of the case, given that the AR had hidden the entire operation of the scheme from the principal. A contrasting case is that of Ovcharenko. Ovcharenko was a case where the principal argued that the appointed representative had acted outside its authority because the AR agreement prohibited the AR from communicating an inducement to investors, so buying them concert tickets, bottle of wine, whatever, in order to get them to invest. And that's what the AR had done. It was a default judgment was entered against the principal, and there was an application to set aside default judgment. Mr. Justice Waxman thought that that argument was hopeless. It didn't affect the what question. It was an entirely separate question of how it is that you're supposed to go about doing this business, and it couldn't deprive the claimant of their rights against the principal. So one can see that there might be cases where it's harder to distinguish between the what question and the how question, but ultimately each will turn on its own facts.
Now, the principle that Shail's just outlined from Anderson, which is that you have to look on the facts of what the principals actually accept responsibility for, is subject to one important qualifier. And it comes from a much earlier first instance decision in Martin and Britannia Life. In fact, a decision that's so old it was decided under the old 1986 Act before FSMA was in force. What happened in this case was that an individual AR had given advice on a range of matters. And those matters included certain things, such as the taking out of an endowment and pension policy with an insurance company, which fell squarely within the terms of his AR agreement with his principal. But they also included certain other matters, such as the surrender of life policies and a remortgage, so that the funds for those new investments could be provided. And those matters fell outside the terms of his AR agreement. So one might think on the straightforward application of the principle Shail's just outlined, there couldn't be any liability for the principal for those matters outside the AR agreement. However, that wasn't the finding made by Mr. Justice Jonathan Parker in this case. And the reason for that was that he found that there was such a close connection between the transactions on which advice had been given. So on the one hand, the advice in relation to the investments which were being taken out, and on the other hand, the advice in relation to the transactions necessary to provide funds for those investments. That in fact the advice on one was inherently bound up with and incidental to the advice on the other and could not realistically be separated. And so in this case, the principal was found to be liable in respect of all the advice which had been given, including that in respect of which it had not expressly accepted responsibility under the AR agreement. And it's worth noting that even though this is an older first instance decision and one which was decided under the old 1986 Act, the reasoning in Martin was cited with approval by the Court of Appeal in Anderson itself, and therefore can still be taken as a correct statement of principle. The final case which is of interest and which we'll look at is last year's decision in the case of KVB Consultants. It was another first instance case, and it involved application of the principles set out in Anderson. In this case, the claim was brought by investors in 8 investment schemes which focused on the refurbishment of property. And those investment schemes had all been designed, managed and promoted by an AR. The claimants brought claims against various people, including the AR and its principal. And in this decision, they sought summary judgment against the principal on the basis that it had authorised and accepted responsibility for the AR's business under Section 39(3) of FISMA. One interesting quirk is that the same counsel actually appeared as it appeared in Anderson, but this time, as it turned out, with a different result. Paul Stanley, KC, sitting as a Deputy High Court Judge, granted summary judgment in respect of some, but not all of the claims which were advanced by the claimants. And in particular, he found that the AR's activities in promoting and marketing what were found to be collective investment schemes fell squarely within both Section 39, but also the terms of the AR agreement in this case, such that the principal was responsible for them. And because there were no other realistic defences advanced by the principal in respect of the claims, summary judgment was entered against it on these claims. One reason why this case is a useful example is that it shows the court's willingness, where appropriate, to grasp the nettle and actually decide these kinds of Section 39 issues on a summary basis, even though they are, of course, to a certain extent, fact sensitive. But the other reason why this case is of particular interest is that the deputy judge in this case did give quite a useful warning as to the dangers which might arise if one uses Anderson to argue for too narrow an approach in determining the scope of responsibility under Section 39(3). And what was emphasised in this case is that while of course distinctions do have to be drawn, and the approach advocated by the claimants in Anderson, which is that you go for the highest level of abstraction in the statute, it is the wrong one. At the same time, one has to be careful not to dissect an appointment in the spirit of pedantry, which is divorced from commercial reality. And Anderson is also not to be read as encouraging or requiring the court to take an artificially narrow view, or to assist appointers to draft away or around responsibility for business which in reality falls squarely within the appointment and squarely within that which they've accepted responsibility for. The other potential 2 routes to liability can be addressed fairly shortly. Looking first at agency, being realistic and given the focus on the terms of the AR agreement under Section 39(3), it's potentially difficult to envisage what any alternative claim, which is based on contractual agency, would realistically add over and above the claim under Section 39. But there are at least 2 possible scenarios where such a claim could succeed, even where the claim under Section 39(3) has failed. The first of those is where there might be some extra contractual or collateral authorization of the AR's activities, which is not to be found in the AR agreement itself, which is the one referred to in Section 39, but possibly in some other agreement which has been reached between the AR and the principal. And the second way is where there could be a claim which is brought on the basis of ostensible authority. And what that means is that something done by the principal means that a reasonable inference can be drawn that the AR's conduct was authorised, even though in fact it wasn't authorised in that case. And the third and final route is vicarious liability. Certainly, in our experience, this is something which is frequently pleaded, but very rarely succeeds. And it's worth just noting there was also an appeal on this point in Anderson, but it was dismissed fairly shortly by the Court of Appeal. Ultimately, the reason why vicarious liability is often going to be very challenging is that an AR will usually resemble a true independent contractor much more than they do an employee of the principal, or even someone akin to an employee of the principal. And very often the terms of the AR agreement in each case will usually be carefully drafted to avoid any suggestion of employment arising between the principal and the AR.
So I get the short straw of taking you through some of the rules here. So obviously normally the principal stands to gain commercially from the activities of the AR. They might take a cut of the product sold, for example. There might be some other arrangement. And they get to decide that the AR is going to be exempt. It's up to them, not up to the FCA. So what is the quid pro quo? What's the safety net? And the answer to that is the obligations that are placed on the principal itself. In theory, it's the principal and not the regulator that supervises the appointed representative. It's a sort of delegated supervision. The main, and we'll take this fairly shortly because there's obviously, as you can imagine, quite a lot out there, but to give you an idea of where one finds the main obligations. They're found in the FCA handbook, of course, in the supervision handbook, SUP, and the Senior Management Arrangement Systems and Controls handbook, as it now is called, SISIC. Taking briefly the SUP rules, and SUP 12.4 is really where one finds them. Before one gets on to the rules that we've set out in the slide, and importantly, 12.4.22 is the preceding rule. The principal is required to ensure, both before appointing the representative and regularly thereafter, that the representative is suitable, so that they're a good egg. And there is guidance to tell you what that means. You have to look at their skills, their knowledge, their expertise, as well as their honesty. So that, as it were, is the suitability of the AR. Then on the other side of the coin, there are obligations on the principal to ensure that the principal is suitable to be a principal. And you'll see from the rule that's set out there, 12.4.23, there are two aspects to that. Before appointment and on a continuing basis, the principal has to establish on reasonable grounds that it has adequate controls over the AR's regulated activities and that it itself has adequate resources so as to monitor the AR's compliance with its obligations. So it's two sides of the coin. There are then further rules that tell the principal what it must do in respect of the AR. So the terms of the AR agreement are provided for in the next rule, 12.5. It has prescriptive obligations about what needs to be dealt with. And there is then 12.6.11, I'm sorry, there's a typo in the slide, but we'll do a set with corrections. That imposes an obligation to police the AR's compliance with the AR agreement. Now, it's not a direct obligation, it's at one step removed. So you'll see that it's an obligation to take reasonable steps to establish and maintain effective systems and control for ensuring that the AR complies with the terms of the agreement. One then has, in 12.6, a series of continuing obligations and some more specific continuing obligations. So 12.6.1 is about the point in time at which suitability of either the AR or of the principal ceases. So if you have reasonable ground to believe that those suitability conditions are no longer satisfied, you have to take immediate steps as a principal to rectify it or terminate the contract with the AR. And 12.6.6R at the bottom there is self-explanatory but is an important one in cases like Anderson and Sense. Firm must take reasonable steps to ensure that each of its appointed representatives does not carry on regulated activities in breach of the general prohibition, so stepping outside of the terms of the AR agreement. So those are all obligations on the principal. Now, we've put up some of the systems and controls rules, but the point of that is really to make clear that there are specific sub-rules that are binding on the principal in respect of their relationship with the AR. But that is, as it were, is overlaid on the general systems and controls rules that are applicable to all financial firms, having proper systems and controls in place, as they must all do. But in the context of principals and ARs, those rules provide some information and guidance. So 4.1.1r, there is more specific about what systems and controls must look like. And they provide guidance on how to discharge sub-obligations, where those obligations in turn concern systems and controls, like some of the sub-rules that we have seen. Now, as litigators, how does all of this help us and how is it relevant? Well, it gives us potentially another route to a principal's liability. So one might have a case like Anderson and Sense where there are difficulties in showing that the AR was conducting a business that was delegated to it by the principal. And in a case like that, an application of Rule 12.6.6 that we saw earlier, reasonable steps to ensure the perimeter isn't breached, might be more fruitful. So a claimant might say, you, the principal, you failed to take reasonable steps to prevent your AR from breaching the general prohibition. They were off running a Ponzi scheme. As a consequence, I was induced to enter a bad investment and I lost money. Or, potentially more difficult, but is available, you, your principal, you failed to spot that the AR was not suitable to be an AR. He had a conviction for dishonesty or be involved in some other disreputable business. He wasn't a fit and proper person. As a consequence, etc., etc., I've lost out. And these rules, the sub-rules, are actionable under Section 128D. So on the face of it, you show breach, you show causation, you show loss. It can work in the right case, but there are some complexities. Firstly, in relation to the question of breach, it's obviously not enough to just say you didn't spot they were operating a Ponzi scheme, because that's not the obligation. The obligation is about reasonable steps. So you need to say there was a failure to take reasonable steps. And the debate would likely become an expert-driven issue over whether appropriate systems and controls and oversight was put in place and was operated in an appropriate fashion. On top of the breach issues, there are obviously nuances as to how causation would work, because it's open to the defendant principal to say, well, even if I had done everything you say that I should have done, the outcome would have been the same. We wouldn't have stopped the AR doing from what he in fact did. And Anderson and Sense is in fact an example of both of those arguments for a defendant succeeding. So these arguments were run through a systems and controls prism at trial, and Mr. Justice Jacobs said, I'm satisfied the systems and controls were adequate, were reasonable, and I'm satisfied that there's really not much that could have been done in circumstances where the scheme was deliberately hidden from the principal. But in the right case, these types of claims would be available.
As Shail mentioned at the start, the reason why this is all back in the news, and probably one of the reasons why you're at this talk today, is the FCA's recent consultation and subsequent changes to some of the sub-provisions which Shail has just talked about. And of course, the immediate context for these changes was the collapse of Greensill in 2021. And various people, including, I'm sure, the members of the Treasury Select Committee, were somewhat surprised to find out that this firm that had been advancing billions of pounds in supply chain finance, while merrily employing the services of former prime ministers and future foreign secretaries, had actually been operating as an AR of an unrelated principal firm. The way the Treasury Committee put it in their report in 2021, which was that this was using the AR regime for purposes well beyond those for which it was originally designed, which is certainly one euphemistic way of putting it. The FCA's own consultation, unsurprisingly, didn't make pretty reading for principals and their ARs. It identified a very wide range of harm across all the sectors in which ARs operate, and it pointed the finger squarely at inadequate due diligence before ARs are appointed, but also at poor ongoing control and oversight by principals after they've been appointed. And the FCA also had various figures to back up this claim, including that on average, principals, that is, authorised persons who had ARs, were found to have caused between 50 and 400% more supervisory cases and complaints than non-principals, that is, authorised persons operating without any ARs. And following its consultation, the FCA in August 2022 made various proposals arising out of that consultation. And those included various rule changes which took effect in December of 2022. Those proposed changes were largely focused on Sub 12, which Shail has just been speaking about, and they were intended to provide various matters to remedy the harms which the FCA had identified. And those matters included, for example, enhanced oversight requirements of principals on ARs. Those included annual self-assessment and review of ARs, activities and businesses, but also looking at the stage at which ARs are appointed, notification of all intended AR appointments to the FCA, so that's something the FCA can actually directly monitor. And finally, annual reporting for each AR made to the FCA by the principal. When one actually gets into the changes themselves, what one notices is that really they focus more on the guidance that's contained in the sub-handbook than on the actual rules themselves. But there are a couple of points which are of particular interest. The first, and I should say again, there's another typo here which we'll correct in post-production. It should say 12.6.1 AG on the slide. But this is new guidance on where it's likely to be appropriate to terminate a contract with an AR under 12.6.1R. And that may be particularly relevant in those kinds of cases that Shail was just talking about, where a principal has become aware of matters which do cast doubt on the suitability of the AR or the activities which they're doing. Then from a causation perspective, the point at which the principal actually should have terminated that relationship may well be critical, because on that counterfaction, at which point the relationship's been terminated, it's no longer possible for the AR to be going around under the banner of their principal and offering advice on that basis. Secondly, there is also new guidance as to the practical steps which principals can take to ensure effective oversight. And in broad terms, this includes much closer scrutiny of and engagement with ARs than it appears most principals have been accustomed to in the past. And certainly one gets the sense that the FCA very much wants the days of ARs only going into their principal's office once a year for a cup of tea to be a thing of the past. And third and finally, there's new guidance as to the terms of the AR agreement itself, which obviously under Anderson is critical. And this guidance includes the fact that these terms should require the AR to provide the firm with information which is necessary for the firm to comply with its own obligations under Sub 12. But the FCA didn't rule out there being further, much more radical changes in future. And Chapter 4 of the policy statement, which it released in 2022, suggested that there may well be various further areas of potential change. And in particular, and again perhaps unsurprisingly, it's the Treasury which has identified various matters which may well be the subject of legislation in the future. There were various suggestions made, but I think those that are of particular interest are threefold. The first would be requiring principals to carry on the same regulated activities as their ARs. And what this is really getting at is the situation which I think once again lots of people find quite surprising, which is that you might have a firm, a principal firm, who's accepted responsibility for an AR carrying on a specified category of business, even though the firm itself doesn't carry on any of that business day to day. The second point which is of interest is requiring principals to gain specific permission from the FCA before appointing ARs. This has been termed by some people the introduction of a regulatory gateway. Essentially, before any AR could become exempt, the FCA would need to permit that exemption to take place, so it wouldn't all be trusted to principals as it is at the moment. And finally, and this really is perhaps the most radical suggestion, which might well be thought to do away with large parts of the regime altogether, but what has been suggested is in fact placing regulatory obligations directly on ARs. And so I think all of these three, to a greater or lesser extent, would erode the more liberal nature of the current AR regime, and indeed the regime as it has been for the past 2 decades or so. But what's been given and what's been clearly warned by both the FCA and the Treasury is that ultimately such erosion could become necessary if the clear harms which have been identified don't decrease in future. And so we turn now to the final navel-gazing section of the talk. This is where we attempt, the two of us, to divine what might happen, particularly in the claims landscape as a result of the FCA's changes. Just looking first at the claims landscape, and if one is a claimant seeking to bring a claim against an AR, or indeed if one is an AR or principal defending a claim, obviously the first question on your lips might be, well, how is this going to affect things, and how is this going to affect prospects of success? Certainly, from the FCA's perspective, all of these changes are intended to improve outcomes and therefore ultimately reduce the number of claims and complaints being made. I think it's also fair to say that nothing really which the FCA has done appears to have changed the law on responsibility under Section 39(3). And there's certainly no suggestion that Anderson would have been decided any differently under the rules which have just been put into force. It's possible, though, to the extent that the FCA has made clear that it expects much firmer oversight and control of principals, there is at least the potential to see how that could open the door to a court being more ready to find that an AR was akin to an employee insofar as there was direct control and oversight. But at the same time, given the new requirements, it's likely that principal firms will be encouraged to make the terms of their AR agreements even clearer and even more watertight, and that might militate against such a finding.
And coming back to the question of claims, there's an element to which the requirements on a principal firm have been a bit of a wild west. So you have situations like Anderson and Sets where there are obligations written in the rules, but nobody really knows what they require in practice. And you have experts on both sides who claim to have expertise in an area which really involves no more than them occasionally being asked the question and charging people to answer it in whatever way they see is most appropriate. And they turn up and they have a debate, and whichever one the judge prefers, having had his breakfast that day, is the one that succeeds. So, to the extent that there is more guidance and more prescriptive guidance that assists a court in looking at what these requirements actually involve, what is a reasonable way to discharge the requirements. So, to take the example that Will alluded to earlier, there are now a series of indicia of the sort of thing that should get you thinking, maybe we need to terminate this relationship. One of which, interestingly, is where the AR is unable to explain unusually high rates of senior management turnover. Now that is quite a sort of insightful requirement, it seems to me, because it must be a common situation where within the AR there are some shenanigans at the foot. There is some guy who's selling a Midas scheme, and the easiest way for his colleagues to deal with it is by leaving. They don't say anything, they just leave, they move on, they're not happy with it. Now, this is something which now the FCA has said, well, we need to be thinking about as a principle. So it puts flesh on the bone of the idea of what should be tipping you off. And the claimant might say, in our previous example, you appointed a bad egg as an AR, and therefore, I dealt with the bad egg and I've lost out. Well, let's get some disclosure here. Look at this, there was quite a high rate of management turnover. Now, if you, principal, didn't know about that, then you should have known about it, because it's implicit in the guidance that you need to make yourself aware of that. And had you made yourself aware of it and asked the question, there wouldn't have been any good explanation for it. And that would have been a thing that would have obliged you to terminate this relationship, see the guidance. So it seems to me that it does open up avenues for disclosure and different ways of formulating arguments, different ways for claimants to attack the same question, rather than just saying, well, here's our expert and here's what he now says should have been done on the facts of the particular case. But beyond that, we shall see. So I think we're on to time for questions, if there are any. but we've also made it to 2 minutes before lunch, so don't feel like you have to ask any, and you're welcome to come forward and discuss anything with us afterwards. Thanks very much.